Judge, I'm ready.
Give me a second while YouTube's getting booted up.
In Your Honor, I have to ask, I see like 15 people on here. Please.
Getting booted up.
Please.
Those are interns.
Okay.
So let's go on the record on this case. Mr. Allen, if you go ahead and announce the case name and the style of the case.
Yes, Your Honor. The case name is J.L. Highgate Homes LLC versus Justin Jones, DBA Nortex Custom Hardwood Floors, cause number DC-19-09125.
Mr. Jones, go ahead and make your announcement. Just state your name.
Oh, sorry, Your Honor. Justin Jones with Nortex Hardwood Floors, President.
Mr. Jones, you need to go ahead and turn on your video and your audio. All right.
Can you hear me?
I can, but you need to turn on your video as well. So
yes.
Mr. Allen, go ahead and make your opening statements, and let's pre-admit let's pre-admit exhibits first. What exhibits would you like to pre-admit?
Your Honor, I sent in an exhibit list with the ones I think we're going to concentrate on today are 1 through 5 and number 9. Actually, 1 through 9, if we could get those pre-admitted, then I think we'd be okay.
Any objections to 1 through 9, Mr. Jones?
No, Your Honor.
Plaintiff's exhibits 1 through 9 are admitted. All right, let's go ahead. And defendants, did you have any exhibits you wanted to pre-admit? Mr. Jones?
Oh, no, Your Honor. I'm sorry.
Okay. All right, let's go ahead and make opening statements.
Your Honor, by way of background, this lawsuit was filed because the defendant filed a wrongful lien on 2 properties that were owned at that time by plaintiff. Defendant is a hardwoods subcontractor. He ordered materials on these 2 jobs. He was paid for ordering those materials. He actually installed the hardwoods on these 2 properties. He was paid for that work. The third step is sometime later, after work is done on the house, you have to finish out the hardwoods, sand them, stain them, complete them. And plaintiff used someone else to finish out the hardwoods on the 2 properties. However, defendant filed a lien, I guess, for the money he thought he should have been paid for doing that work, even though he never did that work. So he's filed a lien on 2 properties for work he never performed. We filed a summary judgment back in 2019 on the statutory lien, and a order was entered on December 20th, 2019, granting summary judgment as to the property code lien, and that lien was removed. However, the constitutional lien remained in place. The only matters remaining before the court today are the removal of the constitutional liens on the 2 properties and the attorney's fees and expenses owed to plaintiff for having to perform this work to remove these liens. As to the constitutional lien, the evidence will be clear that the work was never performed, and therefore he's not entitled to a lien on these 2 properties. We sent discovery, including requests for admissions, to defendant. Defendant never answered these requests for admissions. So pursuant to these deemed admissions, defendant has admitted he never performed the work on these 2 properties. And additionally, we'll have testimony from plaintiff representatives saying that he never performed the work on these 2 properties. So plaintiff is just asking for a judgment from the court that the constitutional liens on these 2 properties be removed, and for a judgment for the attorney's fees and expenses incurred in having these liens removed. Thank you.
Are you calling in yourself or another attorney as an expert on attorney's fees?
I will be an expert on attorney's fees. I was going to do it in narrative form. I can have another lawyer here asking questions if the court would prefer that.
We'll figure that out when we get there. All right. Mr. Jones, it's your chance for an opening statement.
Yes, sir. This was just it was a breach of contract and followed with a common law fraud. This knowingly, I was fired from the project as I was 75% into it on both properties on 2014 Colon and 8546, I believe, San Pedro Parkway. This is just a clear case of a breach of contract.
And have you asserted a claim for breach of contract in your answer?
Yes, I have.
Okay.
This has been ongoing for quite some time.
Your Honor, if I can address that, defendant has not asserted any counterclaim of any kind in any of his pleadings. He has no counterclaim on file. The only issues before the court are the issues the plaintiff has brought.
During mediation, Your Honor, I went over this information with the opposing counsel.
Okay.
I filed 2 liens on both properties and sent demand letters. Responses to the demand letters just with a general denial, just your common breach of contract.
And again, Your Honor.
So I guess initially Mr. Jones was represented by counsel, is that right?
He was
Yes, Your Honor.
Okay.
The counsel withdrew, I think, the day of the summary judgment hearing on December 20th, Your Honor. Or filed a motion to withdraw that day. I think the withdrawal was opposed by Mr. Jones, so it dragged on for a couple months.
Okay. I'm just trying to pull up the most recent answer. All right, so
I don't believe defendants filed an answer since the original answer on August 16th of 19, Your Honor, which was just a general denial.
okay, I'm just looking right now. All right, Mr. Jones, just so you know that in order to assert a cause of action like you're trying to do here, you have to have a pleading to support it. And
Yes, sir.
it doesn't appear like you have a pleading to support that claim. And so
Does, Your Honor, does the just the filings of the actual physical liens themselves and the demand letters, does that not support?
So you said a few minutes ago that you had a claim for breach of contract and common law fraud. In order to make those claims, you would have had to include that in your pleadings. And so since you didn't include those claims in your pleadings, you can't make those claims at this time. So you can't assert a claim for breach of contract or common law fraud because you never pled them, and your previous attorneys never pled them either.
That's news to my ears. I'm not really. I have no idea why the 2 attorneys on the file would not do so. I'll have to double check that and make sure that you're seeing what you're seeing. So
you can look these up if you don't have a copy of the physical file. You can also look this up online. I looked at the answers and there's nothing there asserting those claims. So, but if you have something else, you're welcome to share screen it and I'll take a look at it, but it doesn't look like anything was filed. So, Mr. Allen, go ahead and call your first witness.
Your Honor, I'll call Liz Hainsworth.
What was the name again?
Sorry, Liz Hainsworth.
Is she here or no? I don't see her. Oh, she's here with you. All right, Ms. Hainsworth, if you could go ahead and raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let's proceed.
Can you state your name for the record, please?
Elizabeth Clore Hainsworth,
Can you spell that last name for the court?
Haynsworth.
And what is your position with plaintiff?
Manager.
And what does plaintiff do? What is it in the business of?
We are home builders.
And how long have you been doing that?
I'm sorry, I did not get your answer.
Can you speak up
Sorry,
loud?
we're home builders.
And how long have you been building homes?
We've been building homes for about 5 years.
And how many homes has Planet built over those years?
So we have completed and sold 7 or 8, and we have about 10 more in production.
And have you ever had a lien placed on any of your homes?
No,
Besides this?
just these.
Okay. And I'm gonna ask you questions about one of the two properties, the 2014 Colon property. Are you familiar with that?
Yes,
Okay. And so Planet built a house at that location, is that correct?
yes,
Did you hire a defendant to perform work on that property?
yes.
And what did he do on that property?
He furnished hardwood flooring material and installed it.
So was he paid for furnishing the hardwood materials?
Yes,
Was he paid in full?
yes,
And then you said he installed the hardwood on the property?
yes,
Was he paid for that?
yes,
Was he paid in full?
yes.
Okay. And what is the next step after the hardwoods are installed?
You complete the rest of the house, and then at the very end, basically when the house is complete, then you sand and finish them, and that's when they, are a complete hardwood floor.
And is that done sometime after original installation?
Yes, usually months after.
I'm sorry, months?
Months.
Okay. And did did defendant complete that work of finishing out the hardwoods?
No,
Okay. So did he do any of that work on the Colon property?
no,
Okay. But then he subsequently filed a lien on that property, is that correct?
correct.
And if I could have you look at Exhibit 1. And can you tell me what that document is?
So this is the lien on the Cullen property,
And how much money is he claiming he's owed?
$5,596.
And is he owed this amount?
No,
Is he owed any amount on this property?
no,
So is this the amount that he claimed he was owed for the right to complete the hardwoods on the property,
yes,
which he never did?
correct.
This lien be removed and deemed invalid?
Yes.
What was the address of the second property on work on?
8546 San Pedro Parkway.
That's in Dallas?
Yeah.
Okay. What work did the defendant actually perform on that property?
Supplied the hardwood flooring materials and installed them.
And, Your Honor, I don't see the defendant on here anymore. Is he?
I'm still here.
Okay.
Still there.
Sorry about that. So he did this, he ordered the materials.
Correct.
Was he paid for that?
Yes,
And then he actually installed the hardwood.
yes,
Was he paid for that?
yes,
Was he paid in full on both of those?
yes.
And did he finish out and complete the hardwoods?
No.
Okay. Did he file a lien on the property anyways?
Yes.
He's been paid for all the work on the property.
That he performed, yes.
Okay. I can have you look at it too. Can you tell me what this document is?
It's the lien on the San Pedro property.
And what amount is defendant claiming he's owed?
$9,483.
And is he owed this amount?
No,
Is he owed anything?
no,
Is this for the work that he wanted to perform to complete the hardwoods?
yes,
So he actually did not perform that work.
correct,
Are you asking that this lien be deemed invalid and be removed?
yes.
If I could have you look at Exhibit 3. When did you first become aware that the defendant was claiming liens on the two properties?
It was probably September of 2018.
And how did you become aware of this?
We received them in the mail.
Were they filed at that time?
No,
And what did you do when you received them in the mail?
we called you.
Okay. So you retained me and my law firm to represent you on this issue.
Yes,
Did you authorize me sending Exhibit 3, which you're looking at there?
yes,
And does this letter explain why the lien was improper?
yes,
And did you authorize me to send that letter?
yes.
And I could have you look at Exhibit 4, please. When did you first become aware of the two liens that had actually been filed?
Sometime in May of 2019,
And how did you become aware of this?
we received it in the mail.
And what did you do?
We called you.
Okay. And did you retain my firm to represent you to respond to these lien filings?
Yes.
Is Exhibit 4 the letter that was sent to the attorney for defendant at that time in response to these lien filings?
Yes.
And does this letter explain why the liens were invalid?
Yes.
And does it explain that defendant had been paid for all the work he performed on the properties?
Yes.
And does it explain why he's not owed any further money on either of the properties?
Yes.
And does it state that you would ask for attorney's fees to have these liens removed if they were not removed voluntarily?
Yes.
Did you hire the firm of Jones, Allen, Fuqua to represent the plaintiff in this matter?
Yes.
Did you agree to pay the firm reasonable necessary attorney's fees?
Yes.
Have you in fact paid the firm attorney's fees throughout this matter?
Yes.
And are you asking the court to grant you an award of attorney's fees to represent you in this matter?
Yes.
Your Honor, I'll pass the witness.
All right, any cross-examination of this witness, Mr. Jones?
I mean, just it's a breach of contract. I was not able to perform.
You need
my
to ask, well, Mr. Jones, you need to ask her questions. You don't, this isn't your time to argue. Just ask her questions if you have any.
Yes, Your Honor. Question: was I able to perform these items per contract?
I'm sorry, can you repeat
The work not performed. Was I able to, per contract, able to perform that work?
I'll object to the extent that he says there's a contract, Your Honor.
Overruled, you can answer.
No, you did not complete all the items on the estimate.
Was I able to, the signed contract, was I able to perform the finalized work per contract to finish the flooring? And if not, why was I not?
I'll object to the extent that I just don't understand it. If he's asking if
The question being is, was I able, per contract, able to perform my final duties on finishing the flooring? So paid.
Do you understand the question?
He's
I
not
think
on the
we
screen
lost him,
anymore.
Your Honor.
Mr. Jones, are you there? Mr. Jones, are you there? Mr. Jones, are you there? All right. Mr. Jones, we can't hear you. Yeah, he left. Miss Rhonda, if you can go ahead and call Mr. Jones and find out what's going on. And ma'am, if you could, when you're testifying, if you could be a little bit louder.
Okay.
If I can pause the YouTube video. There it is. Okay. All right, Mr. Jones, if you can go ahead and proceed with your questions. Mr. Jones, if you can go ahead and proceed with your questions.
I think he's on mute, Your Honor, or on no audio.
Your Honor, my apologies. We got disconnected.
Okay, you may proceed.
Thank you. Question being, was I able to perform per contract to finish the duties of my contract on finishing the hardwood flooring?
You did not stand and finish the floors at either property.
Why was I not able to finish the flooring,
We hired someone else.
which would be a breach of contract? But was I not able to perform my final duties per contract because I was fired?
That question.
I'll restate the question. Was I not able to, not on my own will, to finish the flooring due to being fired?
We hired someone else to finish the floors.
So I was fired per contract not to finish the flooring, correct?
Your Honor, I'll object to asked and answered.
I guess I want to know, why did you guys fire him? That's not 100% clear to me.
Sure, there's a number of reasons. Someone told me that he may have sabotaged one of our properties. We found out that he would not, I don't know if he wasn't carrying insurance any longer or if he just wouldn't believe it to us. He installed the wrong type of flooring on one of the sets. He started asking for payment himself personally as opposed to his company. These were all big red flags, not make us feel comfortable continuing business with him.
Okay.
I'm sorry.
Jones?
I'm sorry, Judge. She's kind of choppy. Could you kind of paraphrase what you said?
Sure, there were a number of reasons that made us no longer feel comfortable doing business with him. Someone told us that he may have sabotaged one of our properties, the Cullum property. He started asking for payments directly to him as opposed to his company. No insurance was provided to us.
Objection, Your Honor.
The wrong type of wood on the stairs at Cullen. Things along those lines.
Okay. Did you have any other questions, Mr. Jones?
No, Your Honor.
All right. Any redirect?
No, Your Honor.
No, Your
All
Honor.
right. Call your next witness.
Next witness will be attorney's fees. If I can testify narrative, I will do that. If not, I can get someone else to ask questions.
Mr. Jones, you have any objection to testifying in narrative format?
No, Your Honor.
All right. You may proceed.
Um,
Go ahead and raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Your Honor, my name is Kevin Allen. I'm a partner with the law firm of Jones, Allen, and Fuquay, which represents plaintiff in this matter. I was licensed in 1993, and I'm currently licensed to practice law in Texas and do so primarily in Dallas, Collin, Tarrant, and Denton counties. Our firm's area of practice is a general business practice, and I practice primarily in business litigation. Our firm represents primarily businesses including banks, car dealerships, contractors, equipment dealers, construction clients, and other various small businesses. We bill monthly and have billed monthly since our client was first sent this lien in September of 2018. I produced our monthly bills as an exhibit, which I think have already been admitted. Considered certain factors in determining
What exhibit number is that?
that would be exhibit number 9, Your Honor.
Okay.
Considered certain factors in determining a reasonable fee, including the 8 factors set forth to determine the reasonableness of attorney's fees in the Arthur Anderson case, which are taken from Texas Disciplinary Rules of Conduct 1.04. In setting this fee, I consider the following Arthur Anderson factors: the time and labor required, the difficulty of the question involved, and the skill required to perform the legal services properly, the likelihood that the acceptance of this particular matter precluded other employment by our firm, the fee customarily charged in Dallas County for similar legal services, the amount involved, and the results obtained. The time limitations imposed by the client or by the circumstances, the nature and length of the professional relationship with the client, the experience, reputation, and ability of the lawyer or lawyers performing the services, whether the fee is fixed or contingent on results obtained, or uncertainty of collection before the legal services have been rendered. There are other factors. The Arthur Anderson factors are not exclusive. I've considered the other matters, including the entire record, the evidence presented on reasonableness, the common knowledge of participants as lawyers and judges, the relative success of the parties, the client's interest at stake. I'm familiar with the charge of attorneys for like or similar services, such as those that have been rendered in this case. Considering the criteria upon which fees are based according to the State Bar of Texas rules, the Texas Code of Professional Responsibility. My currently hourly billing rate is $390. And again, we're billing hourly in this matter. In this case, services rendered to plaintiff include discussions and communications with the client, study and analysis of client files and documents, telephone conferences and correspondence with the court, legal research, review of defendant's motion to abate and arbitration, drafting a response to defendant's motion to arbitrate and arbitration, motion to abate and arbitration, drafted the plaintiff's motion for summary judgment to remove the invalid liens. I reviewed defendant's response and objection to the motion. I prepared for attended a hearing on that motion. We attended a mediation, drafted discovery, reviewed preparation for trial, and attended ethics trial. I believe my firm and I possess the skill necessary to represent plaintiffs in this matter and perform legal services. Our firm has spent approximately 70 hours of time on this case, of which 73 hours of that time were my personal hours. We did not have any time limitations imposed on us by the client or the circumstances of this case. Based on that, Your Honor, through the removal of the statutory lien, we had approximately $12,500 in fees. Through the current time, the removal of the constitutional lien trial, our fees will be approximately $23,500. If this case is appealed to the Court of Appeals, a reasonable charge for the necessary work would be $30,000. If the party seeks a review by the Texas Supreme Court, a reasonable fee would be $25,000. We're asking for the attorney's fees to represent plaintiff in this matter of the $23,500, or if the court just goes through the removal of the statutory lien, it would be $12,500. We're asking for the attorney's fees in the amount of $30,000 through the appellate court, and for $25,000 if it's appealed to the Supreme Court. Thank you, Your Honor.
Tell me again, explain again how you were, for the trial court level, you kind of gave two numbers and kind of explain those to me.
Yeah, the reason is, Your Honor, is the Texas Property Code is clear that you're entitled to attorney's fees for removal of the statutory lien under Texas Property Code section 53.160B. And so through the removal of statutory lien, we gave you a number. It's a little unclear. I've done some research and can't find one way or the other for removal, to attorney's fees for removal of the constitutional lien. So I wanted to segregate those two amounts for the court.
So give me those two numbers again.
$12,500 statutory lien through the statutory lien removal, and $23,500 total amount.
Okay. Mr. Jones, any cross-examination of Mr. Allen?
No, Your Honor.
All right, Mr. Allen, call your next witness.
No further witnesses, Your Honor. We'll rest.
Mr. Jones, call your first witness, and that includes yourself.
I mean, I'll just restate it again. It's just a common breach of contract. It's a breach of contract. That's it.
Mr. Jones, you need to call yourself as a witness. So, do you wish to call yourself as a witness?
Yes, Your Honor. My apologies. I wish I had my attorney doing this. I'm sorry.
Mr. Jones, please raise your right hand.
Huh?
You swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Mr. Allen, I assume you don't oppose him testifying in a narrative format like you did.
I don't oppose, Your Honor.
Mr. Jones, you may testify. I want to remind you you're here under oath. So go ahead and testify, but what you're about to say is going to be sworn testimony unless you tell me otherwise.
Yes, Your Honor.
Go ahead.
This is just a clear-cut case. It's a breach of contract and a common law fraud. The client.
Are you there?
Actually able to complete our contract. They breached the contract.
Your Honor, I apologize. I don't know if it's just me, but I can't hear Mr. Jones.
Oh,
Can't
can you hear me?
Yeah. Needs to repeat. He cut off.
You cut off. Mr. Jones, you'll need to, we got that you said this was a common law fraud and breach of contract. After that, you cut off.
Can you hear me now, Your Honor?
Can you hear? I can't hear him. I mean, yeah, I can hear you, but it's cutting in and out.
I'm sorry. Let me see. Right. Look here now. Your Honor, can you hear me? Apologies.
No, I can't hear you.
Can you hear me now?
A little bit better. Go ahead and try.
It's just, this is a breach of contract and the client only fired me prior to me being able to actually finish my contract, which would be finished before. Our profitability is throughout the entirety of the contract. 50% on the middle, 25% after the installation, and 25% on the finish. The client clearly breached contract by firing for whatever reason they listed, and which be a breach of contract. It's an excuse for letting me go prior to finishing the flooring per contract is the clearly just the contract, and I was not able to finish either property because of it.
Tony, did you get that?
A lot of it was inaudible. I'm doing the best I can. I don't know why.
Is it copy?
Mr. Jones, you can call in instead if that works best. It looks like you may be in your, I don't know where you are, maybe in your car, but I'm not sure.
Yeah, I'm in a vehicle.
Okay, so you may need to call in.
Your Honor, I do want to object just to the extent that we're not agreeing to try any of these matters such as breach of contract or fraud by consent.
I understand. I'm just trying to get his testimony in.
Your Honor, try Rhonda on her personal phone.
No, there's a number in the Zoom that you would need to call into. In the Zoom link.
Where is the call option, Your Honor?
It's in the Zoom link that was sent to you.
Number.
That's fine. Don't worry about it.
All right. Your Honor, I'm looking at the Zoom link and it lists off Rhonda's number and Houston San Jose, New York, and Chicago. Like it's not giving me like a direct path here.
Rhonda says to go ahead and call her.
Okay, fantastic. I will do that right this second.
Aaron Point right there.
Well, I'm not sure what we're going to do here for now. Okay, Rhonda's working on it right now. Okay, he's supposed to be calling in now. She says, hold on. Okay. So my court coordinator is going to call into the call and then have him on the line. So let's see if that works. Rhonda, you're muted right now. Can you hear me?
Yes, I
Your
can
Honor,
hear you.
All right, Mr.
Okay.
Jones, you may
yes,
proceed.
sir. This is just a clear breach of contract and common law fraud.
Mr.
The
Jones,
client, yes, sir.
aren't you still, you have the opportunity to ask questions of Mr. Allen. Isn't that where we are, Mr. Allen?
I think he said no to that, and I think he's gone on to testify.
Oh, we're in his testimony. You're right. Go ahead, you're right, Mr. Jones. Go ahead.
Yes, Your Honor. It's just a breach of contract. I was not able to perform my duties on my signed contract with the client. The client knowingly fired me prior to finishing these flooring for her own intent with, and it's just a very clear case of breach of contract. I was not able to finish nor perform by any means. The client did not even express a valid reasoning, in my opinion, for firing me at the time. This is all prior to finishing, which is a very, very common thing when it comes to home construction builders. The final bill, everybody always tries to, run the other direction, save a couple dollars here or there. The client did not fulfill their signed contract.
And Your Honor, object to there being a signed contract.
Okay, did you have did you want to offer any exhibits, Mr. Jones?
No, Your Honor. I'll just re-express it. It's just a breach of contract. The client did not let me finish my contract that we had together.
Okay. Any cross-examination, Mr. Allen?
Your Honor, first I'll just object. I don't know if we were on the record earlier. I'll just object to the extent we don't agree to try this by consent, breach of contract or fraud or any other counterclaim. The only questions for Mr. Jones.
How would you not? That makes no sense, but okay. I'm sorry, Your Honor.
Mr. Allen, you may proceed. Do you have any questions?
Yes, Mr. Jones, on the Cullen Street property, did you complete and finish the hardwoods on that property?
The client fired me on both properties. I was not able to perform our signed contract.
I'll object as non-responsive.
Overruled. Anything else?
No, Your Honor.
Did you complete and finish the work on the San Pedro property?
I was not able to finish the property due to the client firing me.
Are the amounts you're claiming on the Cullen lien for work you never actually performed?
What's the question?
Mr. Jones.
For the amounts that you're claiming you're owed under the Cullen lien, the lien you filed on the Cullen property for work you never actually performed?
I was not able to perform. The client fired me before I breached the contract.
Are the amounts you're claiming under the San Pedro lien for work you never actually performed?
The client fired me prior to me fulfilling my contract, and she went on oath and was not able to provide an actual valid reason of why firing me.
Did you receive
other
requests?
than emotional?
Did you receive requests for admissions from our firm?
Not to my knowledge.
Is your email address jjones@nortexfloors.com?
Yes.
Okay. Did you answer any requests for admissions sent to you?
Yes.
You did?
Yes, and during mediation, we went over everything as well.
I'm not talking about mediation, and these were actually sent to you after mediation. Did you answer requests for admissions that were sent to you?
I responded yes. And talked to your office, yes.
I'll
Mr.
pass.
Jones, did you respond in writing to the request for admissions?
I believe not. It was a verbal conversation with the office.
I'll pass the witness, Your Honor.
Mr. Jones, did you have any other sworn testimony you'd like to give?
No, Your Honor.
Go ahead and call your next witness.
I have no witnesses.
All right, does the defendant rest?
Yes.
All right, let's do closing arguments.
Your Honor, the evidence establishes the two liens filed by defendant on the two properties are invalid, wrongful, and should be removed. The testimony and evidence is clear that the work was never performed by defendant on these two properties, and a lien obviously cannot be filed for work that was never actually performed. The evidence is also clear that plaintiff gave notice to defendant that these liens were wrongful and needed to be removed, and that plaintiff would take all action necessary to remove these liens, and if so, would ask for attorney's fees to have these liens removed. There's also been evidence that has not been controverted or disputed that plaintiff is owed attorney's fees in this manner in the amount through the removal of the statutory lien of $12,500 and through today in the amount of $23,500. Also asking for $30,000 for appellate court and $25,000 for the Supreme Court. We're asking for the court to grant judgment to remove these two liens and to grant these attorney's fees. Thank you.
All right, defendants, closing argument.
Yes, Your Honor. February 16, 2018, we have a signed contract for 8546 San Pedro Parkway. This contract was not fulfilled. There was a breach of contract with a very common law fraud attempt on 2014 Colon Avenue, October 4th, 2017. A breach of contract was made in the attempt of a common law fraud. Liens were filed. The monies have not been paid, and I rest my case. That's it.
Any rebuttal by the plaintiff?
No, Your Honor.
Okay, the court will go ahead and issue judgment in this case. It's a little unfortunate, Mr. Jones, that you didn't have an attorney. There were things done, obviously, that if you had an attorney, there might have been things done differently. As we mentioned before, you never pled the issue of breach of contract or common law fraud, and so I can't consider those. So I'm going to have to enter judgment in favor of the plaintiff. I'm going to have to we're going to remove both of those liens, and I'm going to award $12,500 in attorney's fees for the removal of the liens.
And I'm gonna bring on my attorney to appeal this.
Okay.
This is very, 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 very not done. I'm gonna have my attorney appeal it.
Okay.
I figured this. I just figured this was a very simple breach of contract, but obviously my attorneys did not file the proper motions, and I will have my my current attorneys appeal and move forward.
I wasn't done actually entering the judgment. We're going to award $30,000 in attorney's fees if this case is appealed, and conditional attorney's fees, and additional. I believe you testified to $20,000 or $25,000.
$25,000, Your Honor.
For the Supreme Court. The court will also.
Where does this number come about? This is just for my own knowledge. I'm actually really curious.
So the numbers that I'm giving are numbers provided in sworn testimony by Mr. Allen, and you didn't have an expert to controvert it, and you didn't cross-examine him on it.
Excellent, Mr. Allen. Be very knowingly, I'm having my attorney go full force at this.
Okay.
So this is going to be reopened immediately by my attorneys.
Sounds good. Anything else, guys?
Okay.
Nothing further, Your Honor.
Mr. Allen, get me a judgment as soon as possible, and we'll go from there. Okay.
Thank you, Your Honor.
Thank you. All right, you guys are excused. Interns stay around, but Mr. Jones, Mr. Allen, you guys are excused.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Allen, you're excused.
We're trying.
There you go. All right, Tony, that's the last thing I believe we have until Friday. So we'll see you on Friday. He was a lot easier to hear after we got him on the
Judge
phone.
Hoffman, you're still on YouTube.
Oh, oops, you're right.